All right, we're going to get started here. Good morning. Welcome to the Judicial Proceedings Committee. This is our vote. We're going to work off of voting list number 6. It's our first voting session. And we are going to start off with Shamari with Senate Bill 535.
Senate Bill 535 prohibits discrimination in the sale or rental of a dwelling to an individual with a disability who has a service or a guide dog and retains them as a pet after its retirement from service. Amendment number 1 takes out references to guide dogs for clarity. Amendment 2 defines service dog.
Do the amendment, go ahead. Can someone just explain is there a need to further define this, or is there a federal definition that this might run afoul of?
The Human Rights Commission or somebody gave me a very good little background, and there were 3 kind of definitions. There's something in housing, something in some Maryland code that doesn't relate to housing, and then there was the ADA. When I was working with the advocates and everybody, they said the ADA has the best definition. So we extracted out of, because it's really long, we extracted out of there the language that fit the bill. But we were, use their language, their description.
Need to define it though, or do?
Yes, well, let's put it this way. I didn't think so, but after looking at their letter that they sent, it was in your file.
Yeah.
I felt like, look, let's just be as clear as possible.
I think you should, sorry. I was just saying, I think because it falls under ADA guidelines, I mean, that would be, because if that definition changes, if you put it in hard writing here, you might go afoul of future ADA delineating factors. So if you leave it as it's currently employed by or worded by ADA, you can't go wrong.
And so there is the federal, there's also a state definition in the local government article, which is pretty much the same.
Difference between them is we get into other animals in the housing section and miniature horses and things like that. So we wanted to stick with dogs, right, for now. And also because I didn't want to speak to and did not know anything about, there's also a long issue about emotionally support animals. I have no information about whether they're ever trained or retired. So I didn't know how any of that would work. So I felt like I should stick with what the bill's primary purpose was to help the blind and the deaf with those highly trained service dogs, which do have a hard stop retirement, which is different than sort of if you had a cat or a chicken or a parrot that you use for emotional support or a lot of other things out there. And I thought if somebody wants that, we can certainly do that later if we have enough information. So that's why I didn't take the whole ADA. Even though the ADA does stick with just dogs, that's good. The other 2 do not. But they also go into a lot of other dog purposes that I don't have enough information or wasn't comfortable with supporting, whether they get retired, how they get trained, or any of that stuff. So I thought that we did was really, I worked with the people that wanted the bill and they.
so that is the case that the ADA specifically only limits service animals to service dogs. There's a specific definition for service dog already in the code, which is a little bit more inclusive than the definition here. And so it's a matter if you all just want to limit this to just dogs assisting the visually or hearing impaired.
Well, the issue is I didn't hear from any, I don't want to do a bill that I don't understand. And what I understood was in these 2 communities, they have dogs that are activated and then hard stop retired. The other issues I don't know anything about, and I don't know where it leads. And so I thought, look, I will do what I really understand. And then if somebody comes back and says, look, here's how this works, we could certainly amend the bill, but I would want to do it with the information that we all would understand and feel comfortable with.
Or is a service dog as defined under federal law? That way you don't have to be, you could just be as broad as possible and then it's already, the work's already done. It's already defined.
My recollection is, sorry.
No, sorry. I don't know.
Recollection is there's a federal house, there's several federal laws, not just the ADA, but federal housing that we come up, the state gonna come under. And my recollection is, my staff didn't bring me the bill file, but I'm pretty sure I'm right about this. Federal housing statute is beyond dogs. The ADA sticks with dogs, but also includes a whole litany of
But that would include
dogs that do other things in other categories.
But that language is broad enough that would
I
include
could look at, let me see if I can find that.
You know what, that's correct.
This is not that.
just dog, service dog
Yeah.
as defined under federal law.
She's saying there are other categories of the ADA that may be more expensive than your.
Service dog. Just say service dog. I don't know. Sorry, Samari.
In housing.
It can include-
Housing Act, service animal, or the- I really did work on this. No, really did.
Sorry, weighing in late to this conversation, but somebody sent me an email, full disclosure, it was my dad and he's a big nerd and he was worried about the lack of definition. And he suggested in the Maryland Code annotated other powers of counties section, when it's left to counties to regulate service dogs, they are limited to professionally trained ones, 13104 service dogs. In this section, service dog means a dog that is professionally trained to aid individuals who are blind or visually impaired, deaf or hard of hearing, or mobility impaired. So that's a definition that already exists that we could maybe point to. Again, my father only sent me the information that it is in the other powers of counties section 13-104. So
Article 13304.
Oh, I thought the definition was really clear. I took the language right out of the ADA. And what was it obviously the definition it's in local government, so I'm not sure how that we could reference it for, but maybe. It does, but the last little, you had visually impaired, auditorily impaired right.
Pull out, under ADA, stick with kind of the high level definition, because I think you don't want to be too prescriptive. As defined by the,
ADA, that was my.
that is a
first-
dog. How about that?
Right. Then I read, because it's really long, that it got into areas that I just didn't have knowledge about.
Yeah.
Like whether these dogs ever do retire, whether they're trained in a way. I don't even know how any of that works, and nor did I hear from anybody that that was an issue. So I thought, well, I only want to address the issue I was asked to resolve, as opposed to starting to go off in other areas. I just think that's the way we ought to, that's the way I'm comfortable doing a bill.
Is a service animal as defined by the ADA that is a dog?
Correct.
Which would also encompass deaf, hard of hearing, visually impaired, but as I understand it, would also encompass those that have like PTSD or something, or they have other ailments that like seizures, and the dogs were able to detect those. So narrowing it, I don't know, is in the best. I think leaving it broader and encompassing everything she wants, but also leaving it for the, those veterans and others that have seizures that require a service dog. And I'm not sure how long, I don't know if they ever really retire those, because they're lifelong companions at that.
Right. I don't know anything about it.
So I just,
definitions is whether the dog is professionally trained or not,
Mhm.
right? And that's
Right.
where you really need the distinction to prevent the folks with the emotional support animals who have a gerbil that's
Right.
anxiety supporting.
Right, I'm trying to stick with that.
A gerbil this one.
And-
Anxiety supporting. And you know, they can have them, but
Right.
We'll put you in group one. Yeah, next week.
What do you want to do with the,
But
okay,
so I'm not, well, I think it's really well drafted. I am fine if we could take the language that Senator Kelly just mentioned to get but again, I don't know anything about how they're trained, if they have to be retired. Just don't know. But I feel like we could easily come back next year if this is not adequate. That to me is the smarter play.
all right, do you want to move the amendment? Yeah, or is there an
The
amendment?
ones he just,
Yeah,
yes, I do.
okay,
Move the amendments.
all right, is everyone all right? Okay. Now the bills before you as amended. Further discussion? Motions for favorable, it's been seconded. All right. Is everyone okay? All right, the bill passes unanimously with amendment. All right, thank you very much. Let's move on to. We go to Senate Bill, and this is Josh, Senate Bill 867.
Senate Bill 867 requires the Motor Vehicle Administration in consultation with the Maryland Commission on African American History and Culture to design and issue a special registration plate designated the Maryland Heroes Commemorative Registration Plate. In addition to annual fees required under state laws, the owner would pay an additional initial fee when the plates are issued. And the MVA is authorized to set the initial fee at a level sufficient to result in a surplus after cost recovery. And all surplus money and any money collected for additional fees must be distributed to the Commission on African American History and Culture.
There's been a motion for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Bill passes unanimously. Excellent. All right, Shamari, you ready for 797? All right, Senate Bill 790.
Senate Bill 797 creates a task force on preventing and countering elder abuse with recommendations to the governor and General Assembly due by December 31st, 2024. It's a 16-member task force. As amended, Senate Bill 797 would add 3 additional members to the task force, those being a representative of the Montgomery County Department of Health and Human Services, a representative of the Maryland Children's Alliance, a representative of the Maryland Bankers Association, and 4 additional members, Maryland's Long-Term Care Ombudsman or the Ombudsman's designee.
Motion for favorable to adopt the amendment. All right, it's been seconded, amendment adopted. Any further discussion just on membership? Anyone else want to talk? No? All right, motions for favorable. It's been seconded as amended. Everyone's okay being recorded in the affirmative. The bill passes with amendment unanimously. All right, we're now going to go on to Josh with Senate Bill 705.
Senate Bill 705 is a departmental bill which prohibits the Motor Vehicle Administration from charging a fee for the issuance of a new certificate of title to a surviving spouse when the surviving spouse is not listed as a joint owner of the vehicle. There's already a prohibition on that. And ownership of the vehicle would have to be transferred in accordance with all existing statutory provisions.
A motion for favorable has been seconded. Is everyone okay? All right, bill passes unanimously. All right, we're now on to Senate Bill 706. 706, yes.
Senate Bill 706 is also a departmental bill that requires an independent contractor's employer to report specified information to the Child Support Administration in the Department of Human Services. The bill adds a definition of independent contractor and employee and alters definitions of earnings and employer and statutory provisions related to child support enforcement.
Motion is for a favorable. It has been seconded. Is everyone okay being recorded in the affirmative? Yes, Senator Sidner.
I think this is the bill that I had a question that we were making certain that we weren't pulling in individuals. Was it clarified that when we were talking about employers, that we're talking about businesses and not necessarily individual people?
Well, I think Senator Sidnor, the question concerns the definition of employer on the bottom of page 2.
Yes, sir.
So we're adding in a person who is paying earnings to an independent contractor for services provided in the course of the employer's trade or business. So I think the concern was, if you hire someone to fix up your refrigerator, are you now an employer? I think that is not in the course of your trade or business.
Very
So the answer would be no.
Thank you.
Senator, you're okay? Okay, so is everyone okay being recorded in the affirmative? All right, that's 706. Okay. All right, bill is passed unanimously. We'll now move on to Senate Bill 707. That's Jamie.
This departmental bill requires each deputy state fire marshal, including an individual who's appointed to the office of state fire marshal for training before regular assignment as a deputy state fire marshal, to remain in a probationary status for a period of 2 years after the date of appointment by the office of state fire marshal. Additionally, the bill specifies pay requirements relating to promotion. There are no amendments to the bill.
Motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, the bill passes unanimously. We'll now move on to Josh again. Senate Bill 709.
Senate Bill 709 is a departmental bill that extends the term of a commercial driver's instructional permit from 180 days to 1 year. The bill also exempts a holder of a commercial driver's license who applies for a renewal from the requirement to pass a vision test if that individual has a current certificate of physical examination on file with MVA, which is required under federal regulations.
It's been seconded. Is everyone okay being recorded in the affirmative? All right, 709 passes unanimously. We'll move on to 710.
Senate Bill 710 is a departmental bill that expands the circumstances under which a report or record concerning child abuse or neglect may be disclosed to specified school personnel or the director of a licensed child care facility or child placement agency. The bill authorizes the disclosure of report or record concerning abuse or neglect to school personnel following a report of suspected child abuse or neglect committed by specified individuals, as opposed to current law, which is only child abuse and not neglect. A report or record concerning abuse or neglect may be disclosed on request to the director of a licensed child placement agency following a report of suspected abuse or neglect alleged to have been committed by a household member, family member, or any person having responsibility for supervision of a child in a home that has been approved by the agency for the placement of children. And finally, the bill removes a requirement that a report of suspected abuse committed by an employee, contractor, or employee of an independent contractor of a school and has to involve a student of the school. and a report of suspected child abuse or neglect alleged to have been committed by an employee of a licensed child care facility or placement agency has to involve a child who is currently or was previously under the care of the facility or agency.
Like it does a lot, and I would just ask for the courtesy of a hold so I can explore it more, but it's adding a lot to the code, and I just feel like I wanted more time to look at it. I didn't really pay attention to it.
Of course, absolutely. Senate Bill 710 is on hold. All right, we'll now move on to Senate Bill 711.
Senate Bill 711 is a departmental bill that extends the application of the Child Support Intercept Program to specified payouts from sports wagering or fantasy competitions.
Motions for favorable. Second, all right. Is everyone okay being recorded in the affirmative? All right, Senate Bill 711 passes unanimously. Jamie, you ready for Senate Bill 527? And then Shamari, we're gonna go to 486.
Senate Bill 527 alters the term peer support counseling program to instead be peer support program. It also removes related references to counseling, counseling services, and counseling session, and requires that a peer support program and related service and training be evidence-based.
All right, it's been seconded. Is everyone okay being recorded? All right. Senate Bill 527 passes unanimously. We'll now move on to Senate Bill 486.
Senate Bill 486 increases from 1 to 3 the number of assistant sheriffs required to be appointed by the Baltimore City Sheriff, and allows the Baltimore City Sheriff to appoint up to 4 social workers and any additional sworn or civilian personnel that are funded by the sheriff's operating budget or under other funding source.
Bill, my question continues to be, why does the General Assembly have to pass a bill about the staffing of Baltimore City Sheriff's Office? That's what we're trying to get out of, so when the police. Why is that? Maybe a bill next year to devolve the sheriffs into the counties.
Same thing with the golf carts. Let's do that. All right.
Right.
Motion for favorable. Do we have a letter? Oh, yes.
There should be a letter in your voting pack, but
Sorry, additional questions? All right, it's been seconded. Everyone's okay being recorded in the affirmative? So, all right, Shamar, we're gonna stay, so. Oh, no, not at all. Hold on, Shamari, let's double check on that. So the motion just.
okay.
Seconded, everyone's okay being recorded in the affirmative. All right, Senate Bill 486 pass with amendment passes unanimously. We go on to Shamar, we're gonna stick with you. I think we're on the bottom of this next page here. Can we go to Senate Bill 478?
Senate Bill 478 extends the time for the submission of the final report of the Maryland Lynching Truth and Reconciliation Commission to December 1st, 2025, and extends the termination date of the commission to June 30th, 2026.
Motion's been made for favorable and seconded. Everyone's okay being recorded in. Sure. All right, Shamar, this is a committee amendment that added the entire committee of sponsors. Okay,
And this is 478.
478. Okay. Is everyone okay with that amendment? There you go. All right. So now the bill is before you as amended. Motions were favorable. It's been seconded. All right, the bill with amendment passes unanimously. Excellent.
Me. Yep. Senate Bill 450 prohibits a landlord from using a lease or form of a lease that contains a provision that limits tenant's ability to summon or penalizes a tenant or individual solely for summoning the assistance of law enforcement or emergency services. Prohibits a landlord from taking retaliatory actions against the tenant because the tenant or individual summoned the assistance of law enforcement or emergency services. And it prohibits local jurisdictions from enacting nuisance laws that penalize a tenant for summoning law enforcement.
So motion seconded, motions for favorable has been seconded. Is everyone okay being recorded in the affirmative? All right, excellent. Senate Bill 450 passes unanimously. Let's go, Shamari, let's go ahead and just go with Senate Bill 792, and then I think you're almost out of the woods. We'll give you a break. And Senate, so let's go to Senate Bill 792, and then we'll go to Senator Carter. It was just Josh with Senate Bill 33.
Thank you.
Go ahead.
Senate Bill 792 establishes requirements for the registration and termination of domestic partnerships with the Register of Wills. It repeals provisions regarding legitimacy and illegitimacy of children and provides for the parentage of children born or conceived by registered domestic partners. It requires the Register of Wills to recognize as domestic partnerships relationships established under laws of other jurisdictions if the laws are substantially similar to the provisions of this act.
All right, it's been a motion made for favorable. Let's do, so it's been seconded. You're down. You're up. Oh, you move favorable? Okay. So this is Senate Bill 792. It's been seconded. Is everyone recorded, being okay, being recorded in the affirmative? Okay. The bill passes unanimously. All right, now we are on to Josh with Senate Bill 33.
Senate Bill 33 repeals provisions related to gubernatorial approval of a decision of the Maryland Parole Commission to grant medical parole to an inmate serving a term of life imprisonment. There is an amendment in your packet. The amendment simply adds an additional repeal of another provision in the Correctional Services article, which refers to the Parole Commission making recommendations to the governor regarding parole for individuals serving life imprisonment. So because, yeah, with the bill, the Parole Commission would no longer be, or rather the governor would no longer be involved in that process. So there would be no reason for the Parole Commission to be making recommendations to the governor.
All right, let's move to adopt the amendment. Is everyone okay? Seconded on that? All right, now the bill's before you as amended. Further discussion? All right, this motion for favorable. It's been with amendment. It's been seconded. Do we need a roll call or is everyone okay? Roll call.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden.
No.
Senator James.
Yes.
Senator Washington.
Yes.
Senator Kelly.
Yes.
Senator McKay.
Yes.
Senator Carter.
Yes.
Chairman Smith.
Yes. All right. Bill passes 10-1 with amendment. All right. Let's go on to Senate Bill 257.
Senate Bill 257 establishes the task force to assess the viability of free phone calls for state incarcerated individuals. The task force must analyze data related to free prison phone call programs in other states, evaluate the projected program cost to the state of Maryland, and evaluate and make recommendations to allow for phone calls to be made free of charge by individuals confined in state correctional facilities while minimizing financial costs to the state. There is one amendment in your voting packet. It would add a representative of the vendor which currently provides telephone service for individuals confined in state correctional facilities to the task force. I'm also aware there was an amendment from Senator Waldstreicher to change the name of the task force. I was just trying to get the language on that. Thank you. So that amendment would be to rename the task force to instead use the word no charge and would make conforming changes.
All right, so let's take the amendment 3233251 first. Is everyone okay with the amendment being adopted? Some motion for adoption, seconded, everyone's okay. All right. You want to take the second amendment? Is that the no charge amendment 55? No, sorry, this is the same one. Okay, by voice, got it. Is everyone okay with that?
Yes.
All right, pass it. The amendment's adopted successfully. Okay. Now the bill's before you is amended. Is there a motion motion for favorable as amended? Is everyone okay? Okay, you want roll call? Okay, so just hold again. Yep. The Senate Bill 257 as amended passes 10-1. All right, there's Senate Bill 616 has been withdrawn, so the motion's for an unfavorable withdrawn. Seconded, everyone's okay. Excellent. All right, Senate Bill 385, Jamie.
Senate Bill 385 prohibits a court from assessing costs on a person or governmental unit for recording and indexing as a money judgment an order of restitution issued by any court in the state, as opposed to recording it in the court that issued the order.
Discussion. All right, motions for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, the motion bill passes unanimously. Senate Bill 385 passes unanimously. All right. Shamari, are you okay with Senate Bill 67?
Yes.
Okay, let's go with Senate Bill 67.
Senate Bill 67 requires a civil commission appointee to contact the clerk of the court to which the commission was delivered to coordinate administration of the oath. It deletes the requirement for monthly reporting to the secretary and repeals obsolete provisions relating to taxes on commissions.
Motion is for a favorable. Seconded. Is everyone okay being recorded in the affirmative? All right. Passes unanimously. Okay. Bill 71.
Senate Bill 71 specifies. Senate Bill 71 specifies that 25% of the net recovery by a debtor on a claim for workers' compensation indemnity benefits is subject to execution on a judgment for child support arrearages. There is an amendment in your packet. The amendment would simply remove some language in the bill relating to the interaction of the bill and the Federal Credit Consumer Protection Act. There was some thought that this language might cause some confusion, so I think all the stakeholders agreed they would make no substantive difference if to remove that language.
All right. I'm gonna move the amendment. Is everyone okay? Just gonna get seconded. Is everyone okay adopting the amendment? This is Senate Bill 71. It's the amendment 283022. All right, now the bill's before you as amended. Is there a motion, discussion? Motions for favorable with amendment. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 71 as amended passes unanimously. Senate Bill 40.
Senate Bill 40 sets forth the circumstances under which a custodian of records, in accordance with Maryland's Public Information Act, must deny or allow inspection of recordings from body-worn digital recording devices worn by law enforcement officers. The bill's provisions do not apply to a public record that has been entered into evidence in a court proceeding and may not be construed to affect the discovery or evidentiary rights of a party to a civil suit or criminal prosecution. There are two amendments in your voting packet. The first amendment this is Senate Bill 40. The first amendment in your voting packet is amendment numbered 613521. And it would add to the required denials. Going to the reprint. Depiction of the death of a law enforcement officer that occurred in the performance of the officer's duties.
Yeah, go ahead. Senator Sinner, good.
So this, when the bill was originally drafted, there was a drafting error, a miscommunication. This is language that had been in the bill since I had introduced it some years ago. There was a section that was supposed to have been removed. This was supposed to stay in, so this corrects a drafting error for the bill. So I think if any of you all have seen, there certainly has been some opposition to this, but I think those who are opposed to this, they're also just generally opposed to mandating certain non-disclosures. So anyway, I certainly move the amendment.
Like the bill without the amendment,
I like the bill with the amendment. Good.
And if I may, and I've said this in my testimony, and those of you who know, my uncle was a law enforcement officer in Baltimore City. He had a good friend who was killed in the line of duty. This was put in just because of what I remember was just the repeated playing of the at that time the audio recording of this man losing his life. Again, the opponents of this would then say, well, now I'm trying to treat police officers differently, and that's not the case. What this bill does is it gives those who have been affected and by things like this. So let's say this officer who was killed, their family, they would have access to the video footage just like any other citizen, and if they wanted to disclose it, they could. What this does is it puts some control in for those families. What has also been mentioned, well, maybe let's say a regular everyday citizen would like to do the same thing. I would have loved to have done that at some point, but again, it goes against a lot of what has been talked about, which is making certain that the public is aware when there's certain actions taken that lead to an individual's death. So again, I think the amendment makes the bill better and would ask that you all leave it in.
Just real quick for council, which amendment are we on? Just to be very, because we have two amendments that are in the package, so make sure we're discussing the right
So
one.
we were on 613521/1. That's the chair's amendment. Very similar to the next amendment.
So were you, Senator, just to be clear, you were speaking to your amendment, not the chair amendment?
They look to be at the same amendment.
So you can explain it.
Sure. They are in the sense that they prohibit disclosure of the part of the recording depicting the death of a law enforcement officer. But the difference is also in the other required denials from the bill is introduced. In the chair amendment, the language above is left in, and that's on the bill reprint page beginning on the bottom of page 5. So they would, as the bill was drafted, still be required to deny inspection of the part that does not result in an arrest, attempted arrest, temporary detention, attempted temporary detention, search, attempted search, citation, death, injury of an individual, use of force, as the list goes on.
I got you.
And obviously,
So this is similar to the bill from last year.
I'm trying to remember the exact language from the bill last year, but yeah, the primary difference between the two is just that those things that didn't result in those incidences would be required denials with the chair amendment, whereas the next amendment actually instead strikes those things.
So the chair's bill would not make public inadvertent photographs of the policeman going to the bathroom and stuff like that.
You're going to get a coffee, you forget to turn your
That's right.
camera off, you're going to the bathroom to relieve yourself.
Unless there was an arrest that happened.
Yes, I moved the
sometime.
chairman.
That's fine. That's fine.
All right.
That's fine.
So the motion is for favorable. It's been seconded. Is everyone okay being recorded? Okay, so it's adopted. All right, now the bill's before you as amended. Discussion. All right, motions for sorry, Senator Carter.
Short discussion, so hear me on this, every member of this committee. I'm sure that the bill is leaning in the direction of being passed, but I generally object to the shall language in all of these provisions. I think that there could be unanticipated circumstances that could warrant the disclosure of some of the things that are now mandated to be prohibited. So I just wanted to state that, I think the world, and I know how much this bill is meant to use in Isidore, so it's difficult for me to, say anything against it. But I have had a lot of struggle with it over the last couple of years. I've been happy that it didn't pass up until now. I'm not sure if I'm gonna be able to give a favorable, but in spirit, I understand why it matters to you. I just believe that the reason that we have a custodian of records is to make those discretionary decisions. Now, don't get me wrong. I think that some of these things are important in terms of victims. And we already say, like with body worn camera footage, that, it shouldn't display victims and the like. But just to be so prohibitive and with the shall language on so many of these things, it does concern me. I just wanted to note that. And I could imagine that a circumstance could happen in subsequent years where we come back and do a tweak to this and say that there could be a circumstance where this should be disclosable.
Senator Folden.
Clarity, the bill as amended then would accomplish what Senator Sidnor is asking with those few other unique circumstances that your bill does, or your amendment. Okay. Yeah, no, I inadvertent, I get it. I just wanted to make sure that it encompasses everything that Senator Sidnor was trying to achieve. Thank you.
All right. Senate Bill 40 as amended passes unanimously. All right. All right. We do one more quick one and then we'll go on to another. So Senate, I don't know how much discussion this one's going to engender, but Josh, Shamar, yeah, actually it's Josh, Senate Bill 303. And then we're going to go to Shamari next.
Senate Bill 303 authorizes a placement of one speed camera at the intersection of Maryland Route 333, which is Oxford Road, and Bonfield Avenue in Talbot County, subject to existing signage and placement requirements for speed cameras. There is an amendment in your packet, number 483122/1. So this would change the way that the funds generated by the camera could be used. So in the bill currently, it requires that funds be used in and around the specific intersection where the camera is placed. Under the amendment, the funds would be able to use by the town of Oxford for road and pedestrian safety anywhere in the town.
Move the amendment. Motions for the amendment. It's been, everyone's okay adopting the amendment? Okay. Now bills before you as amended. Sure, Senator Sinner has a question.
And this is to council. I'm assuming signage is required.
Correct. I mean,
Very good, thank you.
Motion for favorable with amendment. All right, so the bill passes 10-10. Oh, so you have a question? Sorry, my fault. Yeah, sorry, my apologies.
Already voting for me.
Sorry, I thought you were.
I just want to go on the record as saying I am obviously against speed cameras for the most part anywhere. This one I understand, but I still feel that there's other traffic calming measures that could be put in place to slow this down and accomplish their goal, like speed humps, real wide speed humps, slow cars down. Huh? All right, so for those reasons, I will be voting unfavorable.
So there's a motion for the motion for favorable has been seconded. I think everyone's being recorded in front of us except for one. So bill passes as amended 10-1.
Hold them against.
Hold them against, yeah. And then we're gonna go to 147. That's Josh.
Senate Bill 147 increases penalties and points assessments for violations related to participation in racing or speed contests. The bill also establishes a statewide prohibition on exhibition driving and authorizes a police officer to order the towing and impounding of a vehicle that is driven in a race or speed contest or exhibition driving. So at a previous voting session, the committee adopted an amendment which eliminated from the bill penalties relating to causing death in races or exhibition driving. There is an additional amendment in your packet. That's number 643727/1, and this would clarify the definition of exhibition driving slightly. So in the current definition, it includes transporting a passenger in an area of a motor vehicle not intended for passenger transport. Under the amendment, that would be clarified to be transporting a passenger on the hood or roof of a vehicle. That's from the sponsor.
No concern. What I saw on TV this morning with officers chasing people through the streets to save their lives and others. Is there a way, and is it necessary to add an amendment that would say if they've got the driver's license, they don't have to chase them for the car, just go get it at some point. What would happen? Kill the person. It makes it easier for them if they can get a driver's license, go back later and get it so they don't feel like we have to get them at that moment. And it doesn't put anybody in danger. That may not be necessary, but I think it helps police officers because sometimes they feel like they really do have to chase it down. The whole thing is, get the car, bring the people to justice. Police officer was hurt badly, people were hurt badly. If they could just get the driver's license and stop, and at least stop them with, from doing what they're doing where they are, go back later and give them the authorization to pick the car up and impound it at that point.
Please. So here, I've said this before and I'll say it again. I'm glad that they moved it to just the hood or roof area because pickup trucks, people were allowed to carry people in the back of trucks legally. So that clarified that. But any one of these, understand, any one of these offenses stand alone. If it's your spouse, my spouse pulling away from a traffic light because they did not, I got one amendment, but I see they didn't change it. So there's no definition of exhibition driving. There's an amendment that I had that had exhibition driving listed as requiring the gathering of people for the purposes of watching, the people, the events happening. So we have no definition of exhibition driving, first of all, but we say that it means any one of these things by themselves, which are already covered individually in the transportation article as payable offenses. So now we don't have a clear delineating definition of what exhibition driving qualifies as or is. And now we have duplicative charges. One can result in you losing your property, being towed away, and one could be a $70 payable fine, depending on the officer. My concern comes in is, if somebody has a Tesla's rapid they're very rapidly acceleration. By this, there's so many subjective standards that are in those enumerated offenses. It is subjective for the excessive abrupt acceleration or deceleration. So by this, if somebody's cat runs out in the road and my wife slams on her brakes all of a sudden on Coastal Highway because somebody's dog gets a hold of them, by this, if the officers doesn't see that but sees that rapid deceleration, could she have her vehicle towed? Yes. Could she be charged with a must appear arrestable offense? Yes. This is something that's worked for Ocean City. If they need that, that's fine. But to put this on officers to be so subjective, and what is excessive or abrupt acceleration? Abrupt acceleration would be, boom, you go. Teslas are a one gear type vehicle. They go, right? And if she's sitting, even if they changed, right. But that's what I'm saying. They can accelerate from 0 to 60 in 2.6 seconds, and it's not a reckless acceleration. But if someone even if they added the definition of what exhibition is by having people there, if you had people leaving the beach on Coastal Highway, going over to the Bayside for their hotel, and a gathering of people was at the traffic light, and there was a truck full of people badgering somebody, and that person pulls away from the light rapidly, by this law, you'd be able to lock them up and take their vehicle, deprive them of their property, which I think is a whole nother issue as far as an unreasonable seizure of one's property. Everybody's gonna say, well, it's just a towed. We're allowed to tow it. But here's the thing. When you tow somebody's vehicle, you're required to do a search of that vehicle. So is it not a violation then, or does it not creep upon the issues of the Fourth Amendment? And if you find articles within that vehicle as a result of that impounding of that vehicle, have you not unreasonably searched their vehicle or unreasonably seized their property at that point for a payable traffic offense that is enumerated other places in the article? So I object to this. I think that if they want to leave it in Ocean City, leave it in Ocean City. But this as it's written is not the way to solve this problem. It only creates more problems. It creates a subjective standard that puts law enforcement officers who are already under the gun on shouldn't say that, but are already under a lot of different stressors from the community. And now we're going to put them in a subjective position to take away someone's property. And then if this group lights up this officer who's doing their job by this bill, if they get numerous complaints, we just heard the mayor's coming in wanting the authority to convene a board so that they can have their own accountability board at public pressure, even though it might be justified by this, that officer could lose his job for doing his job.
Understand? Oh, I'm sorry. Go, please.
No, I think.
But with the language change, some things that you would take out of that, and is there language that would limit it, that would make it more?
I offered some language amendment that said any of, when you get charged with aggressive driving, you have to have 3 of the enumerated offenses. I added something to say 2 of them. Yep.
So the same thing. So I had similar questions about that definition. I think that Senator Fulton, you know how you like go on too much at the very last thing, you lost me on that last statement. But I agree to some extent, and I wanted to know what, if anything, was the rationale for not accepting that amendment for the clarification of that definition. And then the second thing I wanted to just point out is Senator West. He makes a good point about the duplicativeness of the charges, but that is the case throughout our code, particularly when it comes to traffic, guns, and other things. So whenever we finish working on that criminal, whatever the penalties, classifications, we need to deal with this issue. It's ridiculous. I mean, so Senator Fulton, you're 100% right. It's just throughout the code everywhere already.
I will say one thing, whatever we do, Worcester County does want, whatever we do, Worcester County's got to be kind of exempted out of it, because what they're doing is they want to keep, and it's working for them. I don't want to touch that, because that exhibition driving event has migrated elsewhere, and it's working for them, and it hasn't been abused yet. So I don't want to touch that, but so whatever we do, we've got to exempt out Worcester County, but anything else you want to do is fine by me. But Senator James.
I remember this discussion, and I had written some notes to myself to sort of address what Senator Fulton was concerned about. And the language that was put in is getting us there. It's modified now. Senator Fulton has been in close proximity to a crowd or gathering in a manner that intentionally results in. But to make it even a finer point, because I don't know whether it would make any sense to make them like to get 3 elements, but you could say that intentionally and repeatedly or extendedly causes or results in. So you would either have to have them repeating this action, which means one quick acceleration or deceleration would not justify, this, or extendedly, meaning that if you're swerving and it doesn't just happen once, but you keep swerving, to me, and you have to give to me, we can't define it to be 3 or 4 times, but to be repeatedly and or extendedly, which means it's repeated action or it occurs over an extended period of time, that would be dealing with loud noise.
You can have a combination of any of these to be able to at least articulate what they're doing. Articulation is the key to being able to have an enforceable standard. So having one standalone is too subjective. But if you made it to where it was like 2 or more of the enumerated offenses,
But listen to me,
that would help. And the language isn't even right here because it talks about vehicle moving.
Bill, but listen, Senator, what I'm saying is it would
Move
be.
unfavorable.
Can you listen? If I say repeatedly, it has to happen more than once. In fact, it has to happen, it has to repeat.
That would go against what they're trying to achieve in Montgomery County, because it's not repeatedly, it would be an extended operation of breaking
What,
traction with the
repeatedly or
ground and
extendedly, those two words, either or,
extend,
think about it.
well, and Mr. Chairman, look, there's not,
It helps it a lot.
Can we do a bipartisan amendment that would do the following? One, leave it as it is in the county, and which, leave it as it is. And then the language that will streamline, or streamline it for all the other counties. And I think that would handle, you want to do a bipartisan amendment?
or we could just do a Montgomery County amendment to make it a Montgomery County bill.
I want this to be bipartisan. Let's do this.
No, I'm all right.
Thank you, Mr. Chairman. So I'm a little nervous. We're going a little too far in the opposite direction. So I do think on something that we have to perhaps more cleanly have a mens rea requirement, an intent requirement that's part of the bill. And I think that helps solve a lot of the concern and unreadiness with the bill. But requiring a crowd, I worry, goes too far. It depends on how you define that, but oftentimes they are not doing this just for a standing crowd that has gathered. They're doing it for each other. And so in Montgomery County, they went to the parking lot at the border between Prince George's County and Montgomery County, off of Cherry Hill Road. And it was just one big parking lot. And they stayed in their cars, but started doing donuts and other exhibition driving. They were, unquestionably a danger to the people that they were driving in on, but they were also a danger to each other. And so the crowd doesn't have to be a civilian crowd. They could be doing it for each other, and they should still be covered under the act.
And I agree with you, but the points you're making are already covered under the transportation article by two very serious offenses. One is a 12-point offense, reckless driving, which requires the element of a willful or wanton disregard of persons and property. That's the only thing you need to know and to achieve. The threshold is any act that is willful or wanton with disregard to persons or property. That's a 12-point offense. It's already, I think it's like $590. The other one is negligent. The other component of that is that negligent requires a careless operation or of a careless or imprudent manner that endangers persons and property. So there's two levels right there. You already got the tools short of seizing their vehicle. No. Why are you're gonna arrest somebody and impound their car when we don't even impound people's cars for DUIs?
That's the policy choice. I mean, that's the point. I mean, that's the.
That's why the bill.
Then if it's the county, certain counties are asking for it, then give it to those certain counties. But to make this a statewide bill, and especially since I've just pointed out that there's other issues with this, and you guys want to leave it alone in Worcester County, that's fine. But when you start adding it statewide to such a subjective element, when there's already things on the books that'll allow for that, if you want to do something, make reckless driving an impoundable or a towable offense. If you do something in a willful or wanton manner, then it's done. You have it covered then. But to sit here and do all these things, I mean, reckless driving is already a 12-point violation. And in other states, you can have for reckless driving be arrested. Any willful or wanton act that puts persons or property in danger, that satisfies what you're trying to do. You change the punishment for reckless driving. You don't do this and do all these enumerated offenses because it causes problems and it's already in the books.
It's a much cleaner, more nimble solution.
I think it's then it's a standard that's achievable, willful and wanton.
All right. Actually, look, we're gonna vote again on Monday, but let's Monday or Tuesday, sorry. Everyone like Monday.
So are we gonna hold this with that type of amendment being brought forward, or?
Yeah, I mean,
I would like to make
whatever we do, yeah. Basically, you would.
Easier to leave Open City as is and exclude this county and pass a bill.
Well, no, I mean, the amendment would,
That's
I mean,
true.
honestly, like what you're thinking about would just strike the entire bill and make reckless driving an impoundable, a must appear, as I don't, or whatever, I mean, whatever choice you want to make, but, go ahead, Senator Wiltshire.
If we're moving that in that direction, but before we hold the bill, we should talk to the sponsor, but also I think we should include negligent driving as also impoundable. That just needs to be on the table.
About way down to do everything. I think they should.
Senator Foley, it's freaky. How do you just read, you know, it's funny, we're reading the statute and it was, you did it word for word. How many tickets have you been writing, man? You're like, yeah, no, it's good. You know this. That's good stuff. All right. All right, so let's hold it. We'll work with the sponsor, but that's I think it's a better solution than anything we've been coming up with. All right, so let's do this. Shamari, you got Senate Bill 651.
Senate Bill 651 requires a real estate broker or an escrow agent if a purchaser terminates a real estate transaction, if a contingency isn't met, to distribute trust money to the purchaser within 30 days after a certain written notice of intent to terminate is sent. It requires a holder of trust money who makes a certain distribution to notify the seller and purchaser of the distribution within a certain period of time, subject to certain exceptions.
Required to give their money back without any penalty.
Yes.
Okay.
Somebody remind me, what was the nature of the opposition?
In summary, oh, I'm sorry. You can add to it, was the idea that there could be dispute and that would be better left to litigation, but nothing in the bill, if there is a dispute, would stop it from being held to go to litigation. This is where it is clear that that deposit should be returned, and the realtors and brokers all testified in favor, because they don't want to hold on to this money in escrow for no reason either. So there wasn't I believe the opposition was meritless.
It was the Title Association and the Maryland Building Industry Association. They essentially, as Senator Carter stated, said that they didn't want to be caught in the middle of any disputes over whether a contingency had been met or hadn't been met, and that the purpose of the litigation is to have a factual determination as to whether a buyer is entitled to their escrow money back.
All right, it's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirm? We have one down. Senator Fulton. All right, Senate Bill. So it was passed 10-1. 10-1.
Yeah.
No, I said it passes 10-1. Sorry, not. No, so that was Senate Bill 651 passes 10-1.
I think we're very, very close to concluding our conversations on this. I know Senator Waldstreicher wants to, do you still want to think about it, or have you thought about it enough? So I got a call from Sarah Love, who's been the instigator of this bill and been pushing it for years. And she suggests, we've already taken out of the bill the provision that says if someone ceases to be a supervisor of a minor, the the former supervisor and the minor cannot get together sexually. That part of the bill has been taken out. So it now only applies to someone while the person is actually serving as a supervisor of a minor. And minor, we're talking about 16 to 17-year-olds. So Sarah's suggestion, which I think is a good one, is to leave the existing law the way it is, which prohibits any relationship between teachers and minors, and add a new provision that says if you are a supervisor of a minor and you are 6 years or more older than the minor, you cannot engage in a sexual relationship. Most of the concern about this bill is related to kids in college and stuff like that. If you use the 6-year gap, you eliminate the college problem. And so that was Sarah's suggestion. And I think frankly, it's a reasonable compromise and will solve most people's problem with this bill.
Here, Mr. Chair. So are we abandoning person in position of authority and exchanging the word supervisor? Is that,
Just use that as an easy way to say person in position of authority. That's
so we're
what I meant.
still, we're
That's what
still
I meant.
contending, we're still broadening the definition of person in position of authority.
Right, person in position of authority.
And we are not, you were abandoning the other potential amendment that you had mentioned before
Yes.
that models after a myriad of other states that says that that person would be using their authority over the
Yes, I think
further in a sexual relationship with a child.
I suggested that precipitously. Subsequently, I had conversations with state's attorneys, and they said adding that language would make it very, very difficult to successfully prosecute a case, because the person who preyed on the minor would claim he really was in love with the minor. It wasn't his position of authority he used. He was desperately in love with her, and it would be very difficult to get a unanimous jury verdict beyond a reasonable doubt that that person had used his position of authority to prey on the minor.
I understand, just that it was something that was more commonly used in other places, so I
Actually, only 1 or 2 states have that language. So it's not like it was used in a lot of places. 2 states are trying.
Do those other states have an unrestricted broad definition of person in position of authority, as this bill suggests that we do? Do they have limits? How do they?
The research I was provided did not contain any details crimping the definition of person in position of authority.
So it's
So I haven't
broad,
gone
could
back
be
to the
anybody.
actual statutes. I'm using a summary of the statutes prepared by people who did the research. And there was no suggestion that they cut back on the definition of person in authority.
Thank you so much. So Senator West, I almost called you Delegate West because we go way back to those days, but just so I understand the amendment, because I think it solves for a lot of the concerns that I was hearing. With the amendment, this new section of statute would say that the person in the position of authority, and it has, again, volunteer, coach, et cetera, all those components, but they would have to be having sexual contact with someone 6 years age difference. So it would eliminate any of the confusion that someone got into a voluntary consensual relationship with someone who was remotely age appropriate. It would be a minor in the circumstances then with the amendment. If my daughter was a camp counselor and she robbed the cradle inadvertently, and I don't approve of that, she would not be caught in this, for example, as long as there's not a 6-year age difference.
And was 16 or 17. I don't think there were any counselors more than 6 years older than me in my summer camp. They're all college kids.
Right. So it really eliminates any of the potential bad scenarios of over prosecuting situations we could come up with.
That's my view. And let me add one other amendment if I could. If we're going to do this, I want Senator Folden substituted as the sponsor of this bill. I'll be a co-sponsor.
Absolutely. I'm with you. Let's go. So moved.
Okay.
Senator Folden, you want to go ahead?
No, that's all. I was just moving the amendments. I'm sorry.
So you like the amendments?
I'm gonna have to like them if we're gonna do anything with this to at least alleviate people's concerns, but still make it a crime to prey upon these young, impressionable boys and girls.
Good.
Yeah. It helps me a lot. Because I thought we were too broadly defining authority, but I actually think the 6 years satisfies me because, as I stated before, I don't think that those adults should be having, any adult at a certain point should be having sex with the child, whether you define, whether the tennis instructor or the teacher.
Just, I want to have council explain back what the amendment in concept is. We're going to have something before us in writing, but I want council to just explain back what he thinks. So.
Right now, the current law as it applies to teachers says that the age floor for that is 21. That's the triggering age that makes the person subject to the statute. So with this, teachers would stay at 21, but everybody else would go up an additional, go to 23, or do you want it specifically at a 6-year age gap instead of like a fixed age for the offender? 6-year age gap. Okay.
6 years older than the minor.
So repeat it one more time, just make sure you got it.
Okay, so teachers stays at 21. That's that age gap fluctuates. So depending on the age of the victim, it's either 5 year or 4 years or 5 years. But for everybody else, the age gap is static at 6 years if you're that person in a position of authority. Okay, I think, yeah, I can draft that up.
Okay, so we'll have that finally dispose of this bill next time around. Is everyone is okay? All right. All right, so that's it. We'll hold that. We'll bring it up next time. Okay, does this sound okay?
Can we approve me as the sponsor?
Oh, yeah, we can do that. Was that real? Oh, that was real. Okay. All right. All right. So then we can adopt that right now. Motion. So we can swap this. Senator Fulton will be the primary sponsor. Is everyone okay with that? All right. Motion that amendment's adopted. Sorry. We'll have the rest of the amendments in the voting packet.
Is it all right if I draft those as JPR amendments?
Yeah, it's fine. Yeah. All right. All right. With that, that's wrapping up today. So we'll see you guys on the floor. That ends the session for the day.
And then,
Oh, let's do floor leaders and we'll gobble off.
that's gonna be a lot.